This is True North, Navigating Law with Dean Rich Freer, a podcast from Emory University School of Law. Dean Freer, a nationally recognized scholar and award-winning teacher, has been part of Emory Law for more than 4 decades. In each episode, he shares stories and conversations with students, alumni, faculty, and thought leaders, exploring the values and vision that define Emory Law.
Hi, I'm Rich Freer, Dean of Emory University School of Law. Welcome to our True North podcast. You know, True North is our mission. It is a shorthand that we always know the direction in which we're going. Every initiative is held up against that mission to prepare, educate, principled, sophisticated legal professionals who can thrive anywhere and serve their communities. And one of the aspects of this is our top five priorities: student flourishing, academic eminence, our centers, clinics, and programs, fiscal accountability, and our culture of support. Today, let's focus on academic eminence. And my guest today will be Professor Deepa Das Acevedo, who will be talking about her new book, The War on Tenure.
There's something that connects every graduate of Emory Law. It's more than a degree. It's late-night study sessions, lifelong friendships, mentors who challenged you, and a shared commitment to justice. Today, that same community depends on you. When you give back to Emory Law, whether through a gift, mentoring a student, hiring a graduate, or sharing your expertise, you help open doors for the next generation. You help ensure that talented students have access to scholarships, transformative experiences, and opportunities like the ones that shaped your career. Your legacy isn't built in the past, it's built in what you choose to do now.
Welcome to the True North podcast. I am delighted today to introduce my colleague, Deepa Das Acevedo, Associate Professor of Law here at Emory University School of Law. Deepa, welcome.
Thank you so much for having me.
Of course, I've been looking forward to this. You joined us here at Emory Law in 2023. And I am so interested in your research and teaching interests because they are broad-ranging, and they play into your background as an anthropologist, PhD in anthropology, JD, both from the University of Chicago. And this informs your field work, it informs your legal doctrinal work, policy work, and I just think it's fascinating that you bring all these things to bear. And I want to mention 2 threads along that way. And of course, you've published a number of outstanding articles in major journals, but I want to talk a bit about your books and focus on your most recent book. And of course, in 2024, you had an Oxford University Press book, The Battle for Subramala: Religion, Law, and Gender in Contemporary India. Next year, you will have another book, and that's on the judicial system of India. But I want to focus on your work in the regulation of employment. You had an edited volume on the regulation of gig workers. And now let's focus on your most recent book. It was released in the fall of 2025, The War on Tenure.
That's right.
From Cambridge University Press. First of all, congratulations.
Thank you.
It's been very well received. It's a remarkable piece of work, and again, I congratulate you.
It is part of a timely conversation for better and for worse.
It really is true. And let's start with the idea of what is tenure, because we certainly hear a lot of people, various quarters, who are criticizing higher education generally. And one of the targets of that is this tenure idea. So let's start with a definition. What is tenure? And what is the classical justification?
Sure. So now most people, when they're asked, what is tenure? They'll reply with something like, tenure protects academic freedom. And that's true enough. But that describes what tenure does, not what tenure is. Tenure is a particular form of employment contract that provides a heightened degree of job security compared to what's available to most American employees. And now I think we need to back up a little bit to unpack that. The vast majority of American employees, back of the envelope calculations might put this at 75 to 80% of employees overall, are subject to what's known as the at-will rule for employment contracts. Now, the at-will rule is something I get my students to recite in class in employment law. When we get to around week 7 or 8, they're saying it in unison in the middle of class. The at-will rule stipulates that either party to an indefinite employment relationship, something that doesn't have a limit of 2 years or 5 years or so on, either party can terminate the relationship for good reason, bad reason, or no reason at all, anything except an illegal reason with no advance notice and no payment in lieu of notice. So tenure is one of many types of contracts that acts as a kind of exception or a carve-out to this rule that you can imagine creates a lot of employment insecurity for the people who are subject to it, right?
Certainly, yeah, absolutely. Well, is tenure unique? I mean, tenure, we think of tenure in the academic space, and in the academic space, is that unique? Are professors the only people who have that sort of protection?
Well, we're in a law school environment. The answer is always it depends, right?
True.
Tenure both is and isn't very special. It is definitely not unique either in name or in substance, in the sense that lots of employees, I would estimate again about 20 to 25% of employees overall, are subject to various forms of just cause contracts, of which tenure is one type. Basically a just cause contract is saying your employer needs to have a reasonable reason, a just cause for terminating you. So in substance, tenure is not fundamentally unique. Even in name, tenure isn't unique. This is a little bit of a small example, but orchestra musicians actually have tenure, and they call it tenure. But more importantly, lots of employees have heightened job security in the form of a just cause contract, like federal workers, anyone who's employed pursuant to a union collective bargaining agreement. They're also exempted from the at-will rule.
Right. It could be a collective bargaining agreement or obviously an individually negotiated contract. What is the argument? What are the arguments that people are using against tenure? Because we hear about it in various criticisms of higher ed. What is the problem in the eyes of the critics?
So I think that there are a few commonly articulated criticisms that apply maybe to higher ed more broadly, but often get particularly emphasized in conversations about tenure. And all of these go towards what we might think heightened job security does for the incentives or the behaviors of people who have that kind of heightened job security, namely tenured professors, right? So in the book, one of the things that I try to do is take seriously these commonly articulated criticisms, give them some space and ask, do we actually have any reason to believe in them, to support them? So there are three really commonly articulated criticisms that really go to the worries that people might have, and I think reasonably might have if you're looking at academia from the outside in, about what exactly the heightened job security tenure provides might do to incentives and behaviors by the faculty who hold tenure. One is that tenure encourages professors to engage in bad or predatorial behavior. A second is that tenure encourages professors to be ideologically iconoclastic, to be renegades in the classroom or in their teaching. And the third, probably the one that most of us in the academy are most familiar with, is that tenure encourages laziness, a lack of productivity.
Well, let's focus on that last one, the laziness argument that, once you get tenure, you've got it made, you don't need to worry about how the classroom goes or don't need to publish, etc. So that narrative is out there. And your research gets at that. And what have you found, or what is your research suggesting?
Yeah. So, I mean, I understand where that concern is coming from. It can be hard to imagine that somebody might have significant job security and still want to get up in the morning and do, 10 hours a day, teach multiple classes, do the meetings, write the papers, do the research, all of it, right? Why would you? Well, partly you would because you love the work. And most of us come into this profession because we are significantly motivated by the opportunity to do research and teaching, right? But the other thing that I think is important to keep in mind as far as that lazy professor stereotype is concerned is that there just isn't research to back this up. There's not a lot of research on point, but what we do have suggests that people who publish a lot before they get tenure continue publishing a lot after they get tenure. The added security of tenure doesn't really change the way they go about their work. People who publish just enough before tenure continue publishing just enough. Another thing is that things change over time, both for individuals and for disciplines, and within product types. What do I mean by that? I mean that in a lot of disciplines, law is among them, but a lot of social sciences and humanities fall into this category too, the type of publication output you create changes over the course of your career. You start out publishing a lot of articles and maybe a book in some social science and humanities disciplines that require that for tenure. But then as time goes on, you get more interested in books, in textbooks. Those things take longer to produce. You're likely to produce fewer of them. Does that mean that you are less productive after tenure? Or does it just mean that what you produce has changed?
That's a great point, and it's one of the reasons we cannot let productivity always just fall back to metrics about how many. As a good friend, dear friend, departed friend from this faculty once said, everybody can count, but not everybody can read. So it's a matter of looking at that productivity, and it does change over the course of a career.
Absolutely.
And I think that's just a really great point. I see that in my own life as well. And I also see that point about the love of the job, the love of the calling. It's not a job. All my friends are playing pickleball today. They're all retired. I don't want to retire. I love this.
Yeah, I absolutely agree that most people who enter this profession do so because they find it a vocation, right? But at the same time, I think we need to be a little bit careful because vocations speak can sometimes lead to abusive employment practices,
How so?
Well, if something is your vocation, if you're doing it because you're passionate about it, then maybe you shouldn't care about the conditions under which you're expected to fulfill that work. Maybe you shouldn't care about whether or not you are making adequate money in order to service the immense educational debt you've received. There are lots of ways in which industry watchers in higher ed are wary of overemphasizing the genuine passion that most academics feel for the work that they do because they worry that emphasizing passion will prevent academics from articulating reasonable concerns or worries about the conditions of work.
That's a good point. And I appreciate that. And of course, in some measure, I'm not trying to be flippant, but that's kind of what deans are for, right? To ensure that that's not the case, that anybody's taken advantage of in that sense. But the passion for the work is just so clear.
Absolutely. And I think that it's genuinely difficult to walk the line of recognizing that most of us do this work because we can't imagine doing anything else, and not taking advantage of the people who do this work because they can't imagine doing anything else.
Good point. Good point.
Beginning in the 2026 to 2027 academic year, Emory Law will launch a new concentration in AI and the law, giving students a front-row seat to one of the most transformative shifts in modern legal practice. Artificial intelligence is rapidly reshaping how law is practiced, regulated, and understood. This concentration creates a focused academic pathway for students seeking real expertise in navigating the legal challenges posed by emerging technologies. Drawing on Emory Law's strong curriculum and interdisciplinary collaboration across business and technology, the program builds on one of the strongest AI-focused programs in legal education, supported by Emory University's AI Humanity Initiative. Graduates will signal not just an interest in AI, but fluency, positioning themselves at the forefront of the future of law.
This goes to the whole movement toward post-tenure review, which even in schools that will say they don't do post-tenure review formally, they do, because every year, every professor is reviewed in terms of salary and the like, and you have to sit down with the dean and we have to go through what that year was like. You mentioned from inside and from outside. One of the things you do in your book is try to bring the outside world inside what it's like to be a professor.
Absolutely. And that's why, even though this book isn't anthropological in a classical sense, because I'm not out there doing concerted field work for 12 months, I think of it as a deeply interdisciplinary and anthropological endeavor, because what I'm trying to do is translate academic labor dynamics and practices for a broader audience.
That's good. It is interesting how people who are not academics see our job, and they see it in the classroom, and they see that you teach 4 hours a week, and that's sort of it. Well, what are you, playing golf the rest of the time? But they don't see necessarily the drive. And I want to talk for a minute about something you raise in the book, the investment. To become a professor and to earn tenure, you are making an enormous investment in yourself.
Absolutely. So in the vast majority of disciplines, becoming a professor begins with earning a research doctorate, right? That is stereotypically thought of as being a 6-year investment. I have news for you. Very few disciplines actually generate 6-year PhDs. The average now, especially in social and behavioral sciences, is closer to 8 or 9 years. That's just for the degree. Then now you virtually always have to go through a postdoc period, which is kind of like an apprenticeship. You're traveling around, you're spending 1, 3, 5 years in these short-term appointments, building skills, gaining experience, not earning very much and not enjoying job security. And then, if you're lucky, you will get a tenure stream appointment. Again, this is something that's really hard to quantify, but back of the envelope calculations by various people in kind of academic industry watching have estimated that you have between a 10 to a 25% chance of successfully getting a tenure stream appointment.
It's not an easy market.
It just really isn't.
It's very hard to get in, and then of course to earn tenure, it's not easy. What does the institution get? What is the institutional benefit of having tenured professors? Because you talk about some fascinating things like benefits for the students and the parents. I thought it was fascinating.
I think what's so important to remember is that tenure isn't only benefiting the person who holds it. It is for sure. I'm not going to argue on that point. But tenure is also creating the conditions of possibility for work that we all want done. It's creating the possibility of engaged, active pedagogy and mentoring. It's making possible long-term research projects, whether it's lab science or archival work or field work, that takes time to unfold and really might be very risky because you don't know what you're going to come up with. And yet that research endeavor is what's driving some of our most insightful and beneficial discoveries, right? So it's valuable to both the institution that is making these insights, these discoveries, these kind of growth moments for students possible, but it's also valuable for society at large.
Think about the things that universities bring to society and the asset that they are for the entire community. writ large, the world community, really. You talk too about this investment that we academics make in our careers. You also talk about exit and that it's difficult. What do you mean by that?
We can think about exits in a couple of different ways, right? So we can think about job exits if you just want to move employers but stay within the same industry. Or we can think about industry exits when you want to leave academia altogether and move into some other workforce, right? Unfortunately, for academics, exits of both kinds are really difficult. So with job exits, anyone who is an academic, who's partnered with an academic, who's parenting an academic, knows that the job market is just really difficult, right? There isn't a lot of room out there for new entrants, but there also isn't a lot of room for existing academics to switch employers. So that means that even once you're in, it can be very difficult to move employers if your life circumstances or your employment circumstances make that a good idea. The thing that I think is not fully appreciated with the job exits point is that academia is an unusually institutionalized and specialized industry. So what do I mean by that? You can be a lawyer without working at a law firm. You can be an in-house counsel. You can be a government attorney, right? You can be a doctor in a variety of settings. You can only be a professor if a university hires you to be one. You can't hang a shingle and say, I am a professor. I might be a public scholar, I might be an independent researcher, but I won't be a professor. I have to be hired by a particular kind of institution. Now, those institutions are not going to hire professors of law or of history or of biology. They're going to hire a professor of civil procedure or a professor of labor and employment law. And when you combine institutionalization with specialization, that means that academics face a very thin, sparse, kind of spatially disaggregated job market. Let's put that into specifics, okay? So I primarily teach courses in the labor and employment law space, right? There are 5 ABA accredited law schools in the state of Georgia. Ballpark around 140 to 150 tenure stream faculty between them. Very few law schools have more than 2 labor and employment law faculty. So in the state of Georgia, there is probably at most 10 chances for somebody who wants to be a labor and employment law professor to do that work and live in this state. Really, there's probably a lot fewer. And at any given point in time, there might be none. When I went on the entry-level hiring market in 2017, that's precisely the circumstance that I encountered. No Georgia law school wanted to hire a labor and employment law professor. When I was initially considering coming here, there was one university in the state of Georgia that was looking to hire a labor and employment law professor.
See, we got it right.
So if you want to move your job within the same industry, it is profoundly difficult to do that without uprooting your entire life, your family, and you don't know where you're going to end up. So what all of this means is that if you want to stay in academia, but you want to switch employers, it's profoundly difficult to do that.
It is. That all makes sense. And again, part of this is to bring the outside to the inside, because the academic world is not one people really understand, and why would they? Let me ask you this. What would happen, in your opinion, if tenure were abolished?
Well, so I'm going to preface that by saying tenure is increasingly rare, right? Over the last 30 to 40 years, we've seen a movement in higher ed where we've gone from a roughly 70-30 split in terms of how many instructional faculty are tenured. It used to be around 70%, to now having the opposite. Now about 20 to 30% of full-time faculty are on the tenure track or tenured.
That's a really good point, and it brings us to your title. I mean, the war on tenure. Who is waging that war? Whence does it come?
I think the war comes from a variety of sources with different degrees of specificity and intentionality. So at the most abstract level, the war on tenure is a misunderstanding and a growth of distrust in higher education and its labor practices more broadly. And this is part and parcel of the kind of distancing between American society and our higher education institutions that we've been talking about for decades. But more specifically and recently, we've seen a lot of legislative action against tenure, instituting post-tenure review, as you mentioned, seeking to abolish or constrain or prevent proactively tenured employment at public universities.
From your first class to your final semester, this journey has led to one incredible moment: graduation. As commencement approaches, use the Emory Law Roadmap to Graduation to ensure no detail is missed. Visit law.emory.edu/graduation to confirm your degree requirements, to meet critical deadlines, and to make sure there is nothing hindering your walk across the stage. Think of this as your final checklist. Check your progress today so you can move confidently towards celebration.
And so those legislative efforts, while they've been going on for a while, are not as long-standing as the broader shift away from secure, long-term, tenure stream employment that we've been seeing across the higher education landscape.
And you do see that. You see that across legal education anyway, with tenure stream faculty, contract faculty, and the contract faculty have some degree of job security, but it's term contracts.
Right.
As opposed to tenure.
Absolutely. And I think one of the things that those of us who are inside academia need to be willing to do is to think carefully about what job security is necessary to allow us to do the primary task we're here to do, namely teaching and research. And consider what are the circumstances, what are the contractual arrangements, what are even the terms by which we could arrive at that condition, even if it's not called tenure.
What do you mean by that, even if it's not called tenure? Just the contractual quasi-equivalent?
I think that what I find so valuable and so underappreciated about tenure, besides its role in ensuring academic freedom and kind of intellectual free inquiry, is the job security that it provides. But job security doesn't have to go by the name tenure. In fact, there are lots of employees, as we opened our conversation by saying, who have considerable job security outside the form and the name of tenure, right? So we shouldn't really get hung up on that, but we do need to appreciate and emphasize how important job security is for the work that academics do.
Absolutely. I agree. As dean, I agree completely. Deepa, this has been a lot of fun. Thank you so much for joining me today. And again, the breadth and the richness of your scholarship is just so refreshing and exciting. And I think this book is just terrific. It's deserving all the accolades it is getting.
Thank you so much.
That was terrific. I had such a great time talking to Professor Das Acevedo. Terrific work, interesting work, work that matters. Thank you so much for joining us. Join us next time on True North.
Thank you for watching and listening to True North, Navigating Law, hosted by Rich Freer, Dean, and Charles Howard Candler, Professor of Law. True North is recorded in the Hearsay Multimedia Studio at Emory University School of Law, with digital producer Jamelia May, production manager Tayo Fayemi, content director A. Kenyatta Greer, and original theme music by Chandler M. Greer. If you've enjoyed the podcast, please like, rate, and review the podcast on iTunes, Spotify, YouTube, or wherever you get your podcasts. Share it with your legal community, friends, and family. And be sure to subscribe to Emory Law's YouTube channel to help others find the show and join our growing community.